Okay, welcome to our first session on WTO law, our first virtual session. As you can see on the first slide, we are going to start with a brief introduction as to why the WTO matters and why quite a number of politicians, first and foremost our beloved, with some sense of irony, Donald Trump, hate the WTO or at least have a problem with the WTO, and why the WTO in general has become so important in recent years. So, Trump repeatedly announced that he would pull out the US from the WTO if it doesn't do what the US wants. First and foremost, he seems to have a problem with the WTO's dispute settlement mechanism, the appellate body, but we'll talk about that in a later session. Secondly, he seems to have a problem with some of the WTO's core rules. First and foremost, the most favored nation principle and the non-discrimination clause, i.e., the one saying that you may not discriminate between domestic products and and foreign products. So, plus we have another politician who also had something to do with the WTO recently, Boris Johnson. What does Boris Johnson have to do with the WTO? Well, you may have guessed it, Brexit. Brexit is not only a political question and a political issue, it's also a legal issue, in the sense that the United Kingdom, once it has pulled out of the European Union, has to negotiate on its future relationship. And its future relationship will also be, not exclusively, but also be regulated by WTO law, depending on whether the United Kingdom wants to join a free trade area with the European Union or even a customs union. At the time being, from everything we've heard by Mr. Johnson so far, it's pretty clear that the United Kingdom seeks to negotiate on a free trade area with the European Union because it wants to reserve some of its autonomy and preserve some of its autonomy when negotiating so-called trade deals, i.e. other free trade agreements with other states, among them in particular the US, and therefore it will be necessary to stay in a free trade area with the European Union and not a customs union, because if you're a member of a customs union, that essentially means that you are more or less curtailed when negotiating free trade agreements with outside states. But we'll see more about that when we talk about the most favored nation provision and, in that connection, regional or other free trade agreements. So, about the basics, the very definition of international economic law and international trade law. Why are we talking about the basics and this definition? Long story short, because international trade law is embedded within the broader framework of international economic law. And international economic law then is a subsector of international law. So we could imagine that like, say, a pyramid. And at the very base, the fundament of this pyramid is international law. It regulates behavior then on a subsequent level between states or international organizations and private actors. That is the definition of international economic law by Matthias Herdegen in his book on the principles of international economic law. So as you can see, virtually every cross-border economic interaction is regulated one way or the other by international economic law. Having said that, however, we need to narrow down our definition of international economic law a bit, because there are two understandings. The broad one, which you just heard, means cross-border international economic relationship or relations between states and or international organizations plus private actors and so-called hybrid entities such as ICANN, the one that is responsible for internet domain names. It is partly public, partly private. That's why we call it a hybrid entity. Whenever you don't find a term or you don't find a category for a specific type of actor or subject of international law or law in general, you can use hybrid if it's a mixture. In this case, a mixture of private or public. Plus, what also falls under the broad understanding is international business law and international commercial law, i.e. all those rules regulating cross-border economic activities only within or between private actors, companies, and so on and so forth. So here, however, we talk about the narrow understanding of international economic law, in particular trade law, the focus of this class, of this online class, and at least in a small part, the related aspects of international investment law, i.e., all those rules regulating economic activity between states, host states, and foreign investors on their territory. And last but not least, we'll also talk about some aspects of international monetary law, first and foremost, the International Monetary Fund. Good. But before we start about the material aspects and the procedural aspects, then at a later stage when we talk about the WTO and its dispute settlement mechanism, we'll go back a bit in history and look back at the origins of modern international economic law or international trade law. And where do we go back here? On a side note, when talking about history, essentially we're always looking for starting points. So some go back to the Bible, some try to trace the roots of certain rules back to ancient Greece, to pre-modern times, to ancient Egypt perhaps, Rome and the Jus Gentium. However, we're looking now for the roots of modern economic law, modern trade law, and we look back therefore to the free trade movement of the late 18th century and the notion of domestic interests. And in this connection, we encounter someone we perhaps have heard of, i.e. Adam Smith. Adam Smith is the one, with the invisible hand. He became famous with this one picture by saying that this picture is an imaginative picture, where he argued that the market does not need any hand, i.e. a visible hand that controls market interaction, tells market actors, for example, that they should engage with each other, or that you need a central command structure that says, okay, there is a lack of resources at point A, so point B or market actor B should interact with them. No, they find themselves pretty easily and without any market actor or without any commanding actor to bring them together, more or less. This is what he meant with the picture of the invisible hand, i.e. we don't see a hand and we don't even need a hand. They simply find themselves. This is what he's most famous for, although this is only one sentence in his overall work. He has written extensively also as a moral philosopher, but he's being reminded, so therefore be careful when writing a book or an economic treatise or any other scientific piece. It could always happen that you only write one footnote or have one idea in one single sentence, and this is the one you're going to end up being remembered for. What he also coined, however, is the notion of absolute advantage. This goes back to something that may sound familiar if you look at recent economic actors and how they phrase their trade policies. This is the basic idea that it makes sense to engage with other economic actors, with other states, but only because it helps the state itself. This is the theory of absolute advantage. Or, to quote Adam Smith, if a foreign country can supply us, i.e. the British, with a commodity cheaper than we ourselves can make it, well, then better buy it off with some part of the produce of our own industry, employed in a way in which we have some advantage. So you see here a self-serving notion of economic interests. The big problem here is, while on the one hand, this theory essentially means that interaction, cooperation on economic level absolutely makes sense, there's the big question, what about countries that have no absolute advantage in no economic field whatsoever? And this is where another theory comes in, the theory of comparative advantage. Because if we stick with Adam Smith, that means that some countries will simply be left out. No one will cooperate them because they have no absolute advantage. They have no absolute advantage in, say, producing cars or agricultural products or textiles. So what about them, however? What if a country is not sufficiently good at producing a particular good that it will be relied upon to cooperate? And this is where the theory of comparative advantage becomes relevant. The one we associate with two philosophers, David Ricardo and John Stuart Mill. And the essence here is that the theory of comparative advantage means, and I quote again, this is the basic definition, the ability of any given economic actor to produce goods and services at a lower opportunity cost than other economic actors. So the central element here is the notion of opportunity cost. What is opportunity cost? Well, let's assume there's a hyper-efficient state which could, in theory, produce everything at a very high level, with a very high level of efficiency, low costs, all the expertise of everyone in this country. It's a super organized state, a technocracy, you name it. However, if this state decides to produce everything itself, that means that perhaps there might be some goods that are more valuable on the international trade market. However, it will not be able to produce all of these goods because it also needs to produce all the other goods. So this means that, however, if such a country wants to benefit from its hyper efficiency, it makes sense to focus on some sectors, on these sectors that are where you have the highest demand on the international level, and then you could say outsource or rely on other countries to produce some of the goods where they themselves should rather focus on because they have high opportunity cost if they focused on let's say more sophisticated products. So in other words, let's go back to cliches. Think of Germany. Germany is well known for producing cars and for being hyper efficient, or at least very efficient when it comes to producing cars. They have a good reputation. They have a history. It's also a question of prestige, owning a German car. So if Germany then all of a sudden decides to say, okay, we also have to produce all of our agricultural products to remain completely independent of other countries, and all pharmaceutical products, and all textiles, and everything domestically, it might be the case that they're very good at, hypothetically speaking, unless for those products where they simply don't have the resources domestically, but however, it might be the case that they're very good at producing all of these products, but the big problem is that they then would have less resources to focus on cars, where you have a high demand, whereas there might be a less or a lower demand for textiles, for German textiles, than for cars. So again, for them, because of the opportunity cost, so everything, all the resources that would be necessary to produce all other goods, because of these opportunity costs, it also makes sense for Germany to focus on some products and rely on imports from other countries with higher opportunity, with lower opportunity costs than Germany's. So, and this theory, however, that's a big problem. It does have some problems, some shortages, some shortcomings. First, some of its assumptions are somewhat simplifying because it assumes one homogeneous level of input and a perfect ability and willingness of the units of input to shift from creating one product to another. That's the first problem. The second one is it assumes only two products and two countries. So simply means that, okay, there are two products, two countries. One product has low opportunity costs, the other one has high opportunity costs, so it makes sense to cooperate. It also assumes that prices and costs remain on a constant level, they don't change. And last but not least, it is somewhat omitting the political aspect. So, for example, the giant firm, as Colin Crouch has called it, and obviously enough, it might be the case that there are other countries with high opportunity costs or low opportunity costs, but you would nevertheless still not rely on them because you don't want to be dependent on them, or because you want to ensure that some of the products are being produced domestically. Think of pharmaceutical products, for example. And therefore, however, there have been numerous attempts to refine this model. It still remains the basic model, the basic explanation for why economic actors should cooperate and why we have free trade, and a free market. On an international level, or a somewhat free market, or somewhat of a free trade model. However, in particular, what shall be mentioned here is the so-called Heckscher-Ohlin Theorem, which also observed that countries tend to first export goods that use their abundant factors intensively. So if you have a lot of these factors, then that leads to exportation. And however, at vice versa, on the other side, countries tend to import goods that use their scarce factors intensively. So, for example, if you have almost no petroleum domestically, obviously enough, you will import oil or further reproduced refined petroleum. So, however, to conclude here, the theory of comparative advantage still remains the cornerstone, the theoretical cornerstone of international trade law and free trade on the international level. Therefore, in theory at least, every country has its spot in the international or hypothetical scenario of international, i.e. interstate economic cooperation. However, there are some shortcomings of this model, but it's still the one we use. But I will go back to, I will address this point again when talking about why, or why, for example, countries tend to rely on protectionism instead of simply saying, well, we have the fear of comparative advantage. We have a comparative advantage when it comes to, say, agricultural products. Let's stick with that. Why they resort, for example, to moderate protectionism of their infant industries, for example, because they would say, okay, an infant industry, that's the one we would have a 5-year. The picture here would be, it's like having a 5-year-old play football with pros. No, you first protect your 5-year-old before you send them out on the pitch with grown-ups. And the theory here would be that even though you might not have a comparative advantage in this one field, you might have one day, but only if you make sure that your 5-year-old does not end up on the pitch too early. So, and this leads us back to history and to what actually happened during the 19th century in practice. First, this was international law as a conference system. Congress of Vienna 1814, 1815, and subsequent conferences. So what we could also say is what was lacking were international organizations as we know them today. The United Nations, the World Trade Organization, the World Bank Group, ICSID. All of these fundamental economic actors, or IMF, should also be mentioned here. They did not yet exist in the 19th century. They were not even thought of. They were not even in the minds of policymakers. What they did, they met on an ad hoc basis in several European countries to coordinate their interests, their respective interests, but not more than that. There was no permanent international organization with its own structure, with its headquarters in one country, in one city, with its secretariat, with its permanent staff, and so on and so forth. What else is important to know about the 19th century, about international relations in general, international economic relations in general, was that this was the heyday of state sovereignty. So while we have numerous actors today, in particular private actors, big companies, powerful companies that may or may not have close ties with their respective states, that we also have the role of the individual, human rights law, or international criminal law if you're being held responsible. All these actors, although they did exist, they were not seen as actors in an international sense. They were not seen as subjects of international law. This was, again, interstate law. When we thought about international law, the term national in this connection was more or less described as state, or national was seen as synonymous with state. So it was interstate law. And in this scenario of interstate law, what we did have also was the predominance of the British. And the British, or at least until the 1870s, were committed, they were champions of free trade. So that meant that they used their political power position, and they were a politically powerful actor. They had the biggest, you could say the biggest colonial empire of all states, plus they had extended all the shipping routes. So that meant that they could afford, and this is what some critics remark, they could afford to be champions of free trade because of their predominant market and political position. And what they did were, first, they simply removed tariffs themselves. They said, okay, we can afford to let goods cross our borders to enter our market even without having to pay tariffs for it because we're strong enough for that. And what they also did was trying to convince other countries to adopt free trade policies as well. And this leads us directly to the first modern international trade treaty, the Copton-Chevalier Treaty between France and the United Kingdom, concluded in 1860. This treaty is interesting for 2 points. First, it was not a symmetrical treaty. It was one where the British gave more than they received in return. But again, this was possible because of their dominant market position. When we talk about now, who is the most dominant state now? Still the United States. Well, in the 19th century, that was the British. And in this treaty, they said, okay, all the French customs duties, the tariffs when goods entered French territory, shall be reduced to a maximum of 25% within the next 5 years. While the British themselves, however, said that all French products could enter the British market without any customs duties at all, with one exception, and that's interesting because it somewhat foreshadows discussions we've been having in recent years or ever since, except wine. Not because of wine as a commodity, but as the trend that you see behind it. What do I mean by that? It means that, I guess, British wine producers were afraid of French wine because they knew that the people would prefer the French competitor or French competitors and their products. So they said, okay, we need at least some protectionism for the wine producers, the British wine producers. Or another relation or another aspect could be public morals, saying, okay, the people get drunk with French wine, which now enters our border without any customs duties, which means that they will become less expensive. They get drunk all the time with French wine. Well, maybe we should raise tariffs to raise prices artificially again so the people don't get drunk all the time. Something we know from high taxes in Scandinavian countries, for example, as a means to prevent people from getting drunk all too often. And what we also see here, and that's one of the reasons why we're talking about history in the first place, is some trends. And the first trend is that whenever there is economic decline, countries usually tend to impose restrictionist policies again. And in general, international and European level, what we could also observe here is that there was a long recession, one that used to be called the Great Depression. However, when then the Great Depression from the late 1920s came, there was a new name to be given for the one from the 1870s, and now it's called the recession from 1873 or the long recession. And what was the result? Again, the world went back from trade liberalization and back to adopting protectionist measures. However, a number of countries, and I will mention it in a few minutes, resorted to protectionist measures during this time anyhow. What also needs to be mentioned when we talk about the 19th century, or the long 19th century as some call it, i.e. the one from the beginning of the French Revolution in 1789 until the outbreak of the First World War in 1914. This is why we sometimes speak about the long 19th century. Hobsbawm, for example, uses this term. What also needs to be mentioned here is something called gunboat diplomacy or big stick diplomacy. And this type of diplomacy has two aspects, and it needs to be mentioned at this point because it first explains why we have international investment law, and secondly, it also explains some of the grievances newly established economic actors or emerging economic actors, in particular such as China, have when it comes to the European powers or Western powers. There were two aspects of gunboat diplomacy. The first aspect is that gunboats were being sent, this is where the name comes from, gunboats were being sent whenever investors felt or when indeed their rights were being violated in foreign countries. And this, on the one hand, seems perfectly reasonable. So it's like calling, if you, for example, in a public park, you have a problem with some of the kids there, you're calling your older brother to protect you. This is what companies used to do during the 19th century and also the early 20th century. So, for example, if there was an American company investing in Mexico, and then a new government, and there were lots of revolutions in Mexico during that time, and a new government then would say, okay, let's expropriate American investors, and then the US would say, wait, you can't just expropriate our investors, or otherwise we'll send our gunboats or the man with the big stick, the one you see on the slide. However, the Mexicans did not like that idea that they could not simply expropriate on their territory or investors located on their territory, or relatedly, that it could also be that foreign investors felt that they were being mistreated or not treated in a fair manner. Because whenever that was the case, these economic actors, private economic actors, or at least on a legal level private, obviously enough, they had close ties to the respective governments, in this case the US, and whenever they felt that they were not treated in a fair manner, that they would simply call their big brother, the man with the big stick, i.e. the American state. And then it would send the gunboats and say, wait, not so fast. If you're resorting to expropriation, we'll use force. Gunboats, the big stick, and this is indeed force. Not only economic pressure, economic coercion, this could actually even turn out or become a war where a powerful state, a more powerful state would protect the economic interests of its companies, from its territory, or composed by its nationals. This is the one aspect. The other aspect in this connection is gunboat diplomacy as a means of forcing states to open their ports, for example, or to open themselves to foreign trade. If you look at the Chinese constitution, for example, you might find in the preamble, and there are English translations out there, in the preamble a reference to European conquests or Western policies towards China during the 19th century. So if you write something in your constitution, give that a thought. That means it's important for you. Otherwise, you would not put it at such a prominent position, at such a prominent spot. And the Chinese have not forgotten the 19th century, in particular not the Opium Wars. These were wars launched first and foremost by the British, and this is an absurdity of history, indeed, to balance their trade deficit with the Chinese, because there was a high demand for, say, Chinese porcelain, for example, in Great Britain, while at the same time, however, the British did not have enough to offer to the Chinese. So one thing that they did have to offer was opium harvested in their then colony India and was then exported to China. And when China said, wait, this is bad for public morals, for public health, we're closing our ports, then the British started a war, the Opium War, and there were subsequent Opium Wars as well, where they then officially said this was to protect the investors, for example, because some of the exports were being seized when they entered Chinese ports. But if you look behind the veil, and if you look at how the Chinese perceived it and what actually was the case, this was indeed a war launched to force the Chinese to open their ports to foreign opium, from the British. This is one of the absurd stories of international trade law, however, one that explains why gunboat diplomacy has a very bad reputation and why countries want to avoid such policies in contemporary modern international law. One means of preventing such gunboat diplomacy measures, i.e. force for economic interests, was the so-called Calvo Doctrine. The Calvo Doctrine was named after an Argentine jurist who coined the idea that, yes, we may enter as a country, we may open our market to foreign investors, but only under the precondition that they would then waive their right to call their big brother, the man with the big stick. In the case of the US, for example, the government. And you find the Calvo Doctrine, for example, in the Mexican Constitution from 1927. As you may imagine, has changed repeatedly in subsequent years. But if you look, for example, the version from 1927, in Article 27, you find a perfect textbook example of this so-called Calvo Doctrine. It says that first, only Mexicans and Mexican corporations have a right to acquire ownership of lands, water, and their appurtenances, or to obtain concessions for working mines or for the utilization of waters or mineral fuel in the Republic of Mexico. Okay, so only Mexicans may invest, in modern parlance, in Mexico. And then, however, the Mexican nation, may grant the same rights to aliens, but only under one precondition, provided they agree before the Ministry of Justice to consider themselves as Mexicans in respect to such property. And this is the crucial part, and the one that hopefully becomes perfectly understandable when considering what I just explained earlier, bind themselves not to invoke the protection of their governments in matters relating thereto. In other words, you may come to our country, you may invest there, you may start economic activities, but only if you promise that you will not call your government if you think that we did not treat you in a fair manner. Long story short, this is the Calvo Doctrine. As you can imagine, however, numerous Western countries did not like this idea, simply put, because they did not trust governments such as the Mexican governments. They were afraid that there would be yet another revolution where there would not be a stable economic environment. They were afraid that the courts would not be impartial, and so on and so forth. A basic problem that has remained until this very day, but the modern solution is international investment law. This is the very reason why we have investment arbitral tribunals, why the World Bank is engaged here, why you have other ad hoc investment tribunals where private actors may sue the states where they're being located whenever they feel that they have been mistreated. Whether these courts will decide in their favor is obviously an entirely different question, but the one main goal was against this background, perfectly understandable to get the state out of the picture, because the state as an ultimate ratio means force, possible force or actual force, in the worst case even war. Out of economic interest, you want to avoid such a situation. That explains the emergence of modern international investment law. So, and again, however, going back to tariffs, again in the 19th century, the British were the champions of free trade. However, they were somewhat the sole champions. Other countries were far more reluctant when relying on free trade or free trade policies. In particular, the US relied on tariffs, and for three reasons that are relevant when countries, in particularly poorer or economically weaker countries, also rely on protectionism. The foremost reason is it's a source of revenue. That's how you make money as a state. It's easy to collect simply at the border. You collect customs duties. It goes directly into the pockets of the government whenever one economic actor inside of your territory imports something from abroad. You collect it at the border. Easy to collect as a tax. Secondly, a quasi-tax. Secondly, protectionism, what we mentioned earlier in connection with the so-called infant industries. And last but not least, and this is a powerful argument that has seen somewhat as a, you could say, a return in international trade talks and in US domestic trade talks, a correlation between economic growth and high tariffs was being observed. We don't know, and we will never know, whether the US during the 19th century became a powerful economic actor because of these tariffs or despite of these tariffs. We simply don't know. What we do see, however, is that the tariffs did not prevent the US from becoming a dominant economic actor, but you could also make the argument they would have become even more dominant or even faster a dominant actor if they had not relied on high tariffs. We'll never know. What we do see here, however, is that Donald Trump, for example, today also says, wait, where's the problem with tariffs? We relied on them in the 19th century and everything worked out just fine. So you see here, going back in history, you see how historic arguments can return in present-day trade talks. And also other powerful actors during the 19th century also relied on protectionist policies. The Austro-Hungarian Empire, Italy, Germany, or France were in general rather protectionist. This was, you could say, one of the early phase of free trade, but certainly not on the same level as today, at least when looking at tariffs. And there's another explanation why we rely on free trade, or why there is so much emphasis on free trade. The first one was the one I just mentioned earlier when talking about the comparative advantage principle, or the theory of comparative advantage. More efficiency, and everyone can focus on the products where he or she is best at, or where he or she, as an economic actor, has an advantage, or you could say at least some space to participate economically on an international level. The second reason, and here we could go back all the way to Immanuel Kant and his piece on perpetual peace from the late 18th century, perhaps the one book he has written that is most accessible, most easiest to understand. And he argued that as a precondition for peace, three requirements have to be met. First, we need as many republics, i.e. democracies, in the modern sense, democracies as possible. Why? Because people themselves usually are peaceful. If the people get to decide whether to wage a war or not, they will vote against it, at least in their relationships with other democracies. Second, he argued that there shall be an international organization where states could cooperate on a permanent basis. In other words, a federation of states, or he called it a federation of republics, what we see now today embodied in the United Nations. So Immanuel Kant is an ideological forethinker of the United Nations and his predecessor, the League of Nations. And last but not least, he argued that there shall be economic cooperation and also no debts between states. And this argument was then subsequently picked up by someone called Norman Angell. Somewhat forgotten, he wrote first the book Europe's Optical Illusion and then later expanded it, and he published numerous subsequent volumes, The Great Illusion. And Angell is one of these thinkers who is very often misunderstood. He did not say that there won't be any future wars, although some think that this was his main argument and said that he was naive. That was not what he said. What he said, you find it in this lengthy quote, was that he argued that it simply, from an economic perspective, does not make sense to start a war. And I quote, "Military and political power give a nation no commercial advantage. It is an economic impossibility for one nation to seize or destroy the wealth of another, or for one nation to enrich itself by subjecting another." And why? Because of globalization. Globalization is not an entirely new phenomenon. We already saw that during the 19th century, the days of British dominance. And already in 1910, he said that international finance has become so independent and so interwoven with trade and industry that the intangibility of an enemy's property extends to his trade. It results that political and military power can in reality do nothing for trade. And this is the key argument here. It simply does not make sense to conquer foreign territory. Why does it not make sense to conquer foreign territory? Because you could simply start cooperating, and you don't need to send the gunboats, you don't need to send the guns. Why not? Because there are better means available. Long story short here. So, and however, some said that he was, as I mentioned earlier, said that he was naive because there was indeed the Second World War, there was the First World War, and he did not see that coming, but that was not his argument, because from an economic perspective, neither the First nor the Second World War, obviously enough, made sense. So, and as we already said, if we look back at the interwar period, however, there were again, and as always, when it comes to difficult times, as already argued, states resort to protectionism, and that was also the case after the First World War. World economy collapsed in the late 1920s, in particular the Great Depression, new Great Depression, the one that required a new name, or the world to look for a new name for the older Great Depression, the one from the 1870s. And this Great Depression also led to extreme protectionism. And one example that we have to mention in this regard is the so-called Smoot-Hawley Tariff Act, passed by the US Congress in 1930 as a reaction to the Great Depression. Why do we need to mention that? Because this somewhat gives us a historic perspective on modern trade relationships and shows us that things were even much worse in the past. Why? Because back then there were average duties being imposed that amounted to 59.1%. So when we talk about the Trump tariffs today, when we talk about the Trump tariffs, we talk about, 20%, 10% on steel and aluminum. That compared to the Smoot-Hawley Tariff Act, that's virtually nothing. And this act affected some 20,000 imported goods. And keep in mind, there were far less goods back in those days. So protectionism at a completely different level than today. And that in turn led to retaliation by the US's trading partners, by other states. So a downward spiral, the one you want to avoid, the one everyone is afraid of today. Relatedly, what we also could observe was the rise of communism and fascism, and relatedly, big economic actors closely associated with the respective states or state. So either they were owned by the state or they were at least controlled by the states, even if on the euro level, legally speaking, they were still owned by private individuals. What we also saw during this period, for example, first and foremost in the Soviet Union, were nationalizations. So private property was either completely abolished, or at least the big companies were expropriated, and the owners were expropriated, and their property was being given to the hands of the state. And what we also could observe during this era was something we mentioned earlier in connection with Immanuel Kant, the big problem that the London Economic Conference from 1933 failed to reduce tariffs and settle state debts. And remember, Kant said that state debts are one incentive for states to wage war. However, this issue was not being resolved, unfortunately not resolved, so there was yet another reason why states would go to war with each other. And this happened obviously enough with the Second World War. There are numerous reasons, and this is not time and space to go into detail here, but what we can see, however, is that states have resorted to war time and time again. And the big problem here is that the world then didn't know what to do again. And the basic idea was, okay, let's adopt the very same, or let's continue the route we've taken after the First World War. And what was the route after the First World War? You guessed it right. Again, international organizations. So the League of Nations was followed then by the United Nations, which adopts more or less the very same basic idea that you have a permanent international organization dealing with international peace and security, but not exclusively, but also virtually all other aspects of daily life, of international daily life, from the general well-being to labor law, or you name it. The UN is basically responsible for or has within the scope of its competences basically every human activity you may imagine. But however, what one lesson that was being learned was that tariffs were bad, not only economically speaking, but also bad when thinking about their impact on international peace and security. And what was also the basic idea, the basic insight that was generated after the First World War was that you need permanent institutions that are also more economic in character, and this is where the global economic system was being established, and that was the conference in Bretton Woods in 1944, where the two big IFIs, and you guessed it perhaps already, as lawyers we love abbreviations, and in international law even more so. IFI stands for International Financial Institutions, or institution, and the two we mentioned in this regard is the International Monetary Fund, which was established in 1944, and the World Bank. These are two so-called sister organizations. What do we mean by that? You can only be a member to both of them at the same time, and they have parallel structures and some general principles. The voting procedure, for example, that those states that pay more also say more. That is something you find in both in the World Bank and International Monetary Fund. Both of them are located in Washington, and they're also opposing each other. They're even connected through a tunnel. So this is why we speak of sister organizations. So first, the whole international economic, you could say, the architecture was being built in Bretton Woods 1944 in the last days of the Second World War. And the general idea that you need permanent institutions, international organizations with states, composed of states, to first reconstruct Europe. That's what the World Bank is for, was originally for, reconstructing Europe, and then its scope of activities later expanded to reconstruct or construct the whole world. It finances predominantly infrastructure projects, and however also to preserve monetary balance and monetary stability between countries, cross-border monetary law and activities. That's what you have the International Monetary Fund for. It also may lend other countries money if they have balance of payments problems, if they can service their debts. However, that always comes with strings attached. We'll go back to that when we speak about the Washington Consensus in a few minutes. Plus, what also deserves to be mentioned from this era is the gap from 1947, where you had first trade concessions, where countries would decide to subsequent meetings lower their tariffs. And however, although it was only a small tariff treaty at the very beginning with some 23 members, however, this constituted the first cornerstone of international trade law, and its basic principles have remained unchanged until this very day. What needs to be kept in mind here, however, is that it was only applied preliminary. It more or less, you could say, it became a constant provisional treaty, provisional application, and one of the preconditions in this regard was the so-called grandfather clause. Why was the grandfather clause a precondition, because back in those days, if you were being sent as a negotiator abroad to conclude a treaty, to negotiate on a treaty, and then you come back home and say, wait, now we have to change virtually everything in our domestic constitution or domestic legislation, you may imagine that neither your electorate nor politicians are pretty happy about that. And that's the reason why it was basically agreed upon that many substantive provisions, even though there are obligations flowing out of the GATT 1947, that there was no obligation upon states to change everything only because they joined this treaty. And one last trend that needs to be mentioned from the era right after the Second World War is the attempt to establish an international trade organization, the ITO. You may know this abbreviation because it's still valid today, but today it refers to the International Tourism Organization. But initially, in the period right after the Second World War, there was the basic idea to establish a permanent international organization dealing with trade as a specialized agency of the United Nations. So you could say a close member of the UN family, in contrast to the WTO, which you could say is a remote cousin or a good friend of the family, but not in the inner circle. The WTO is much more independent of the UN, as the ITO would have been had it been established back in the 1940s. What is also interesting about this model is that it was also originally envisaged as not only regulating trade, but also employment, commodity agreements, restrictive business practices, international investments, and services. So one that covers not only international trade law, but a wide scope of international economic activities. But the big problem, or why it failed, why it was not established, was US Congress. US Congress, and you have to understand that about the US or about other powerful countries, they are keen on preserving their sovereignty, whatever that means. Sovereignty, this is one of the terms. Louis Henkin has described it as the S word, in the sense that in international affairs, it's written with emotions, it's not easy to define. Everyone has a different understanding of sovereignty. So in US Congress, some said it's infringing our sovereignty. An international organization regulating trade disputes or being responsible for international trade, we don't like this idea. We want to conduct our trade the way we want it, without any outside interference, and in particular not by an international organization. You have to keep in mind in this connection also that international organizations were a very novel idea back in the 1940s. So while today it's perfectly reasonable, and we all know that there is a vast array of international organizations out there dealing with basically every human activity you could think of, from, say, international trade in bananas to tourism or metrology or health, the WHO, or petrol exporting countries deciding to bundle their political power in OPEC, and so on and so forth. Today, that's a perfectly normal subject of international law. Right after the Second World War, this was a new idea, and many US politicians had the idea that this could be a super state, a threat to our sovereignty. We don't like that, we reject it. And, however, some would say that it was even too liberal. That's the other side of the coin, in the sense that it is too much in favor of free trade. So you can see here again, no one was happy but in US Congress, but for different reasons. And that's why the GATT, the General Agreement on Tariffs and Trade, the one we mentioned a few minutes ago from 1947, then in practice evolved into a de facto international trade organization. However, at the same time, it was never a de jure international organization with a secretariat, with its host headquarters, and so on and so forth. So you see here some pictures, and why am I showing these pictures? Because they also explain some of the, let's say, some of the problems or some of the skepticism, in particular so-called newly independent states have when it comes to the international economic architecture, and in particular the WTO. Because what you do not see on these pictures of negotiators is, in particular, representatives of colonial states. The wave of independence and the fact that many former colonial states became independent only materialized in the 1960s. From the 1960s onwards, you saw a large wave of countries becoming one after the other independent, former colonies. But that also meant that they were not represented themselves at the negotiating table at, for example, the Havana Conference from 1947. That's why they would also, until today, sometimes argue that, wait, the whole international economic system was not designed for us, and therefore, why should we respect these rules? Why shouldn't we not try to coin or draft new rules that are more just, more rules that take our needs and our thoughts, our political considerations better into account? Long story short, however, and now going back to the basic of today, remember, this is the one that emerged after the Second World War, and I may quote now Jagdish Bhagwati in his book on protectionism, where he said that the architects of the liberal post-war order and the ensuing trade liberalization were not merely intellectual believers in the virtues of free trade, they were also the beneficiaries of a splendid historical example, an experience with tariffs that was widely perceived to have been a spectacular failure. And this is the reason why until today everyone is afraid whenever countries decide to resort to protectionist measures, in particular high tariffs again, because in general most view that protectionism from the interwar period, at least of having contributed to in one way or the other to the outbreak of the Second World War, or at least did not prevent it, because protectionism means that what Norman Angell described, what I also described a couple of minutes earlier, that this close interconnectedness between states did not materialize because of protectionism. So, and this leads us to the fundamentals of international trade law, and these have not remained unchanged ever since the GATT 1947. 5 key major principles. The most favored nation principle, the one obliging states to treat other states equally. No special favors for their good friends, you could say. The national treatment obligation, which is the other side of the non-discrimination coin, that states shall not discriminate domestically, they shall not discriminate foreign products in relation to domestically manufactured or produced products. Then none of the existing trade barriers shall be further increased. Rather, in the long run, trade barriers shall be reduced. If countries wanted to resort to protectionism, that was not prohibited in general, but if they wanted to do so, they shall only rely or resort to tariffs, i.e. saying that, okay, if a foreign good wants to enter our market, it has to pay 10% so-called entrance fee. But what was outlawed are so-called import or export restrictions or quantitative restrictions. So if a country says only 1,000 German cars, we've mentioned German cars earlier, are allowed to enter our market, that is a violation of WTO law, more precisely of Article 11 of the GATT. And last but not least, in the GATT 1947, it was also agreed that there would be regular negotiations. So they all had a long, a long perspective. They were looking into the future and said, okay, from time and time again, there shall be negotiations to lower tariffs, to decrease other trade barriers, to harmonize product standards, and so on and so forth. But they were perfectly aware of the fact that you could not impose a system of free trade all at once. And where this is also visible is if you look back at the historic origin or the developments from the 1940s, 1947, where you can see, for example, that there were some qualifications to these major principles. For example, as we said, existing preferences were further preserved. Parts of the Commonwealth, for example, were exempted. So the special relationship between the British and British territories, and the same goes for overseas territories or so-called affiliated states back in the 1940s of France, Belgium, and the Netherlands. Then, the already mentioned grandfather clause. That meant that states, even although they signed and ratified the GATT, were not obliged to change their pre-existing legislation when it comes to, for example, subsidies, all their subsidy provisions, dumping, foreign dumping, so bringing products to your market below market value domestically, below the domestic or the market at home value. State trading and state trading enterprises, powerful actors with a special privilege being handed out by the state or being owned by the state. The provisions on national treatment and quantitative restrictions did not have to be changed already in 1947, and all of the rules on customs valuation itself could also remain in place because of the grandfather clause. What you also could see here were political exclusions that were perfectly fine. So a country could then still say, wait, we were just at war with, say, Japan. We do not want to be obliged to treat Japan just like every other state. That was possible. And national security exceptions were being put in place, so countries could always rely on their security interests to violate some of these fundamental rules. There were general exceptions, so for health, safety, or public morals, for example. And last but not least, quantitative restrictions, although they were in general prohibited, they were legally fine, they were legally possible for agricultural or fishing products. So, what happened afterwards? This is where trade rounds of negotiations become relevant. And this reminds us somehow of the conference system, right? So we have here from time to time meetings between the respective states and members of the GATT. Geneva, Annecy, Torquay, Geneva, Geneva again, then the Kennedy round and the Tokyo round, the Uruguay round and the Doha round. So different trade rounds. And at the earliest ones, it was particularly important to raise global tariffs for all the reasons we already mentioned. In other words, because everyone was hoping that lower tariffs would mean higher probability of long-lasting peace. The Tokyo round then deserves to be mentioned because it was there was a very high, in contrast to the earlier rounds, a very high number of participants. So 102 participating states. And what was also reached there were that there were large cuts in customs duties in major industrial markets. So the powerful countries then said, okay, if weaker countries want to trade with us, well, they will need lower tariffs. We will have to step back from protectionism. And in particular, there was one formula that was being adopted that the higher the tariffs, the larger the cut there shall be. So if there is a 40% tariff on something, it shall be cut by some 30%. If there is only 2% tariff, even if it could be cut by a half and then it would be 1%, that was not the big problem. The big problem was and still are the high tariffs. However, farm trade, as you can imagine, many economically weaker countries have a comparative advantage in farming trade and agricultural products. However, no resolution was found here. And then, however, also shall be mentioned is the Uruguay round. Why the Uruguay round? Because it led to the establishment of the WTO. We'll come back to that. And the current trade round is also the longest lasting one. Simple reason being the economic landscape has changed fundamentally. The rise of China, the BRICS states, Brazil, Russia, India, China, and South Africa. They also have their respective trade interests. So it's more and more difficult to find common ground. And that's the reason why the Doha round has still not been concluded. Good. However, we mentioned these so-called newly independent states repeatedly today. What shall also be mentioned in this connection is something we call the new international economic order. As I already said, many newly independent states, i.e. former colonies, but also so-called non-aligned or communist states said, we do not like the status quo. We want something new. And this something new was the concept of the new international economic order. Why were they so keen on establishing something new? First, the reason we already mentioned, many said that they would never sit at the negotiating table. It's just like us. We're being born. I'm born after the Austrian Constitution was drafted and was concluded. However, I'm still bound by the Constitution. For me as an individual, it's not a problem because as an Austrian, as a typical Austrian, I love the Austrian Constitution. It's drafted by Hans Kelsen, a very sober document, a fine piece of legal art. But with the international trade architecture, it's somewhat different. Not everyone likes it, and in particular those states that were not represented at the negotiating table are not big fans of it. Plus, other states would then say, wait, why do they not like it? They did not like it because they said, okay, it's after all a capitalist international order. The concept of free trade is a capitalist concept. That's why they wouldn't like it. And then they coined a new alternative model, i.e. the New International Economic Order, commonly abbreviated as NIEO. And it has 4 cornerstones. First, the notion of permanent sovereignty over natural resources. What does this concept mean? Essentially, it means that every country is sovereign and therefore also has the sovereign right to decide what shall happen to the resources located on its territory. And that relates to, first, that they call for profit sharing between states and investors. To use a textbook example, if you as an oil-rich country allow foreign companies to operate on your territory, you would say, yes, but we want something in return, and not on the basis of some old treaty that was concluded perhaps when we were in a weak phase, or by a government that has been overthrown ever since, or that was concluded when we didn't realize how important oil was for the world economy, and so on and so forth. This is where they would say, okay, we want to share profits. Then there were lower standards for compensation in case of expropriation. It is also connected with permanent sovereignty over natural resources. National resources, a country would then always make the argument, or could want to preserve the possibility to make the argument that we want to regain control over our own resources, and doing so, for example, because there were previous injustices, because a foreign or a Western oil company had exploited our resources without sharing the profit with us on the basis of an old shady contract. If we want to expropriate them, we don't have to pay compensation at all, or only a low amount. And last but not least, the so-called right to development. That's a human right, but a special human right. Why? Because this is a collective human right. It's not owned by the individual, or also perhaps owned by the individual or the individual rights holder, but also by peoples, by the complete or the entire community of a state, for example, relying on the right to development, on the right to economic and human progress. But however, that's more of a utopian right, of a utopian fiction, than an actual right where you could go to a law court and say, wait, I have a right to development, it has been infringed. It's more of a political concept. Good. And this leads us back to what happened afterwards and during this era. Was that states, in particular newly independent states, were relying when making all of these arguments, profit sharing, that they could always expropriate foreign states, that they enjoyed state sovereignty. And why were they so keen on emphasizing state sovereignty? Because they didn't have sovereignty for so long. What they did have was complete dependence, either as colonial states. They were not even their own. They did not have a separate legal personality, or if they were not colonies but protectorates, there was a legal fiction that they existed as independent states, but their sovereign right was restricted, in particular because the protecting state was not only protecting them but also exercising pressure or exercising influence over these states. That's why many of the former colonies or former protectorates, when they gained independence, they were keen on preserving their sovereignty. And that also affected international economic affairs, as the International Court of Justice held in the Nicaragua case between the US and Nicaragua. It was also the Nicaragua, the new Sandinista government that had overthrown the older Somoza government, was then keen on preserving its right to establish a socialist system, for example. That was none of the US's business, and the ICJ in this connection held that a state is not bound to continue particular trade relations longer than it sees fit to do so in the absence of a treaty commitment or other specific legal obligation. So the downside of that was, while every state has the right to say, okay, we want to switch from capitalism to socialism, for example, or state capitalism, there are numerous economic models out there. However, that is a right. The downside of that is that a powerful state may also any day decide to freeze, for example, foreign aid, or impose an embargo if it sees fit to do so because, for example, of geostrategic interests. That is found already in the GATT. We mentioned it a few minutes ago. Good. However, the situation changed sooner than expected. The Nicaragua case is from 1986. However, some 3 years later, the world changed, and changed for good with the fall of the Berlin Wall and the end of the confrontation, the ideological but also via proxy wars, military confrontation between East and West. And now we come back to someone we had not mentioned yet, or we have mentioned a bit earlier, Francis Fukuyama, yet another political thinker who was misunderstood. Why was he misunderstood? Because he also didn't say at the end of the Cold War that now we're about to enter a period of peace and cooperation and liberalism has triumphed. No, he only said that this was an end of the ideological confrontation between East and West. And in this connection, there was a notorious concept being used by the IFIs. I indicated it earlier. Now you get the name Washington Consensus. Why Washington? As we said, they're on opposing sides in Washington. Both of them are located there. And the Washington Consensus is a set of reforms that are required by states if they suffer from economic crisis, if they borrow money. So the IFIs, the IMF, the International Monetary Fund, and the World Bank would both argue that for them, yes, they would lend money for projects or to help countries pay back their debts. But they would say, we won't simply give out the money to you. It's just like, imagine that was their argument, was similar to this one friend you may have, that the one friend who always borrows money and never gives it back. And you already know that he or she won't give it back, but you give it to him anyways. Well, the World Bank and the IMF at one point decided, say, okay, we want our money back, but however, to get our money back, we have to impose certain restrictions, to ask for something to be given in return. And that was the Washington Consensus, a set of neoliberal reforms as a precondition to receive money by the World Bank and or the IMF. Fiscal policy discipline, subsidies shall be redirected to economic sectors that are promising economic growth, to undertake a tax reform to tax the right groups, privatization, deregulation, and last but not least, enhanced market access for outside actors, i.e. trade liberalization. That all sounds fine in theory, but in practice, however, something associated with it, and I mention him here, Joseph Stiglitz, for example, has written extensively about this impact in his book Globalization and Its Discontents, for example, and this spurred the anti-globalization movement. What he argued was that in many of these cases, the IMF has not taken into account, at least not sufficiently, the need to look at the respective circumstances. And what also could be observed here is a term called shock therapy. Shock therapy says that if a country undergoes economic transition or an economic crisis, there needs to be a shock. So jobs are being lost, pensions are being reduced or not paid at all, but that is necessary for a country to adapt. So it's very tough to endure in the short run, but in the long run, it will be better for the respective country. However, the big price that was paid for that were riots in the streets, a high level of mistrust, political destabilization. If you look at it, however, from a purely economic theory, it might make sense, but what was forgotten by the IMF and the World Bank were the political and sociological aspects, and also aspects of justice associated with it. That's why Keynesians, and in particular also in the anti-globalization movement, I mentioned these books, I may also mention Naomi Klein in this regard, were criticizing globalization, but they were in particular criticizing globalization actors such as the IFIs, the World Bank, and the IMF. The World Bank and the IMF both say that they have learned their lesson, that they now look more as tailor-made solutions and no longer one size fits all for every country the same solution, but many would argue that they have not really learned their lesson, that they still require the same reforms by every country asking for money. Good. Having said that, we'll now go back in history to the Uruguay Round. because that was also taking place in parallel. What was the background to the Uruguay Round? Basically, the deteriorating trade policy environment during the 1980s, many loopholes when it came to agricultural products, legal loopholes when it came to agricultural products, plus services. Trade and services became more and more important. So people were already moving, workers, service suppliers were already moving cross-border, offering the services on a cross-border level during the 1980s. It was the largest trade negotiation until then, with some 123 countries participating at the end in 1994, and it led to the biggest reform of the world trade system since the GATT 1947. The Uruguay Round covered virtually all trade aspects. There were negotiations on market access, so tariffs, standards for products that have to be fulfilled in order to export to a specific country, both for goods and services. Services were also on the negotiating schedule. Intellectual property rights became more and more important and were therefore also negotiated, leading to the adoption of TRIPS, the Trade-Related Intellectual Property Rights Treaty. Then there was a package of cuts when it came to import duties on tropical products. Why were tropical products so fundamental? Because this is one of the products that is being exported by developing countries. This is what their economies rely on. Then revised rules for dispute settlement, because the old dispute settlement mechanism of the GATT was not really functioning, because every country could simply veto the adoption of a report, even including the one country that lost a case. We'll come back to it in our session on the WTO, now defunct but still important trade dispute settlement body, or its dispute settlement mechanism. And last but not least, speaking of mechanisms, what was also established was the so-called trade policy review mechanism. That means comprehensive, systematic, and regular reviews of the national trade policies of all countries, later of all WTO members, because this is the final and most important outcome of the Uruguay Round. While the ITO had failed, the World Trade Organization then was established some 50 years, almost 50 years later, as an independent international organization, replacing the GATT, which has evolved, as we said, de facto into an international organization. And the cornerstone, the fundamental treaty of the World Trade Organization is the 1994 Marrakesh Agreement, named after its birthplace, i.e. the country where it was concluded, Morocco, and the city of Marrakesh. And now we're in the 1990s. And the 1990s, looking back at them from today's perspective, the 1990s were a great time. If you read the articles, there was a lot of euphoria, a lot of optimism that the world was finally moving toward everlasting peace, perpetual peace perhaps, as Immanuel Kant has described it, human progress, economic progress. The world would become a better place. There was no longer the shadow of a nuclear war between East and West, and so on and so forth. On a regional level, we saw increased integration within the European Union. The Maastricht Treaty from 1993 established the now banned but still the EU pillar system with 3 different pillars, where we would have some pillars, in particular the economic one, more and more integration, the European market, other pillars, foreign policy, security, where the EU was still more like every other international organization, in particular requiring affirmative votes by all members for the adoption of solution. And also the Maastricht criteria, which are obviously enough criticized today because it is now said that they do not provide enough flexibility, but the Maastricht criteria held that states would only have a limited amount of possibility for deficits, state deficits in their budget, that there shall be only a moderate level of inflation, exchange rates were being regulated, and interest rates. And in 1995, then again, going back to the international level, on 1st January of 1995, the World Trade Organization came into being as the very first, and it's the international organization dealing with international trade, internationalization, i.e. on a global level with members from everywhere, not like the European Union, which is a regional international economic organization, but only open to European countries, whereas the World Trade Organization is open to countries from all over the world. But, however, also looking at the negative aspects, the anti-globalization movement, some of the violence and some of the some of the criticism that I mentioned earlier was also then taken to the streets in 1999 at the WTO meeting, for example, the so-called Battle in Seattle. Huge anti-globalization protests that led many actors from back then to conclude, wait, something is going on here. Not everyone agrees with our worldview on globalization. In 2001, the Doha Round started, where developing countries and where development is on the agenda, very high on the agenda, in particular helping developing countries. And I'm using this term on a side note because I know on the one hand this is a problematic term. On the other hand, however, because it suggests that some countries are somewhat behind and still need to catch up. But on the other hand, however, this is the term being used by the World Trade Organization itself, and it's also found in WTO law itself. That's why I'm also using this term. It's simply the one term that is used internationally. And then what will also be mentioned here is the 2008 global financial crisis, which is still with us until today. We still suffer from the results. We are now afraid that there could be a global financial crisis that is even more devastating its impact because of the coronavirus. We shall see what is happening here. And the last recent development I want to mention at this point, and then we'll conclude today's session, is what happened in 2012 when Russia decided to join the World Trade Organization, because this was the final nail in the coffin of the Cold War. Whereas the Cold War had already been over much earlier than that. However, this was the final conclusion that the Cold War is over with now Russia, the former Soviet Union, you could say the continuator state of the Soviet Union, joining the somewhat capitalist World Trade Organization, becoming a part and member of the international economic trade architecture. That meant that the Cold War and the military and economic and ideological confrontation between East and West had definitely come to its end. But we'll see how, because Russia, for example, is also not a typical market economy. It is dominated by numerous actors that have close connections to the government. We'll see how that has an impact on international trade law and why WTO is not only composed of market economies. Yeah, and last but not least, what should also be mentioned here, although it's not on the slide, obviously enough. It is on the slide. I'm sorry, I forgot to mention is the year 2001, the year particularly important for economic law and international trade law, the year when China finally acceded to the World Trade Organization with a set of preconditions, a set of obligations upon China on its path towards protecting economic rights of other states located on Chinese territory or goods entering the Chinese market when it comes, for example, intellectual property rights, that they shall not steal from other states or other companies from abroad, and so on and so forth. And as you can see here, many, in particular Donald Trump, has accused Bill Clinton, who you can see on the right, on the top right picture, who was the key figure negotiating the accession of China to the World Trade Organization. And remember, in the 2016 US presidential elections, Donald Trump then accused Hillary Clinton merely because it was her husband. So he accused her or the Clintons as such, of having allowed China to enter the World Trade Organization. However, during the 1990s and early 2000s, the basic argument was that the world cannot afford to prevent China from entering the World Trade Organization because it will grow anyhow, and it's better to incorporate them in the existing international economic system than risking a parallel economic system. Think again when we were talking about the ITO. The ITO was not established because the United States had not decided to join the ITO. It didn't make sense to start an international trade organization without the most powerful economic actor. Wouldn't make sense. It would not be genuinely international, and the same goes for China. An international trade organization, the WTO, without the soon-to-be most powerful economy wouldn't have made sense. That was the state of the arguments, and it's still a reasonable argument today. Good. Having said that, we conclude our first session on the introduction and the history of international trade law. We'll see each other for our next session, where we will talk a bit about the Doha Round and about the current debate about the so-called trade war. And then in the session after this one, we'll continue with fundamental or material WTO law, the most favored nation principle, the national treatment obligation. Hope you enjoyed our session, and see you soon.